calling you on a consultation, you're not going to be speaking to just any member of our staff. You'll be speaking with an associate attorney. And in that brief conversation with the associate attorney, she will identify the issues that we're going to need to talk about in our first appointment. You make your initial consultation appointment and you come in and you meet with myself or Denise. In that appointment, we talk about your situation. Are you concerned about alimony? Are you concerned about time sharing? Are you concerned about equitable distribution, non-marital assets? Whatever it is, we spend an hour talking top to bottom about all of the issues on the surface. And from there, we make a plan. Okay, you want to begin the divorce process? This is how we begin. You don't want to begin the divorce process, but you're getting there. This is what you should do. And what we do is you leave that initial consultation with a game plan. This is what I'm going to do going forward. If you leave the initial consultation, if you've decided to retain our firm, we will represent you from start to finish. You'll pay your retainer to the firm, you'll receive a welcome letter, and you'll receive a packet so that you immediately know what is expected from you, and you will know what we will be doing for you. Starts with the discovery process. You'll be immediately gathering your discovery. You'll start working on a financial affidavit. You'll get your bank statements. You'll get your statements of all of your assets and all of your liabilities, and you'll tell us about your children. You'll be given the statute, and you'll have to think about the factors that the court's going to consider in determining your time sharing. So you leave loaded with that information and ready to provide us with the information that we need to evaluate your case. From that point, your case begins. We'll file the petition for divorce, or if you've been served with a petition for divorce, we'll answer your petition. Or a paternity action. If you've been served with a paternity action where you're not married to the other spouse, but you need to establish your time-sharing schedule or child support or what have you, we'll represent you in that process. So a petition is filed in a divorce, and then an answer is necessary within 20 days of being served. At 20 days, you file your answer. That's what we would do for you. Most of the time, when we file an answer, we also file a counter petition. The petition that came to you said your spouse wants X, Y, and Z. Our answer will say we agree or we disagree that you get X, Y, and Z, and here's a counter petition. And our counter petition says we want A through F. And so these two documents are basically the first shot in a divorce. They're the first things that get filed. From there, everyone exchanges their financial paperwork. They exchange mandatory disclosure, there might be requests for productions, there might be interrogatories, but this period of time is meant for discovery so that everybody knows what everybody has. So that when we go to divide things up, when we go to sit down at the settlement table, all the cards are on the table and we know what we're dividing. Or if there are issues about the children, all of the children's issues are on the table. All of those things come out in the discovery process as well. Are we paying for private school? Do we have special needs for a child? Do we have an aftercare expense, a daycare expense? What are we spending on health insurance? All of that takes place in the discovery process. When the discovery process is over, we'll attend mediation. In Palm Beach County and in Broward County, usually before you see a judge, you go to mediation. Mediation is really yourself, me, or Denise, or Ruby with you at mediation. The other side would be there with their attorney. And in the middle, there's a neutral third-party mediator. And that mediator's job is to see if we can come to an agreement. Can we avoid the expense, the time, the agony of going to trial? And if we can, we'll mediate and we'll get a settlement agreement. Not all the time do we reach a global settlement agreement at mediation, meaning do we reach an agreement that addresses all of the issues top to bottom, from children's issues to financial issues. But if we do, we'll draft a marital settlement agreement, everyone will sign it. You know, this may be a process that takes place in the week after mediation, but we'll get a settlement agreement signed, and then the case will end with a final judgment, a final hearing. That's the quickest way to go. And that usually means that you've gone from filing a petition or answering a petition to a marital settlement agreement without ever seeing a judge. But that isn't always possible because no one can agree on every issue. Children's issues become a major fight. Alimony becomes a major fight. What's the amount, but what's the duration? These are things that people can't necessarily agree on because the numbers aren't clear. And it's a gray area in the law where maybe you have an advantage over the other party in court, and maybe the other party thinks they have the advantage. So you don't settle. You go to the next step, which is usually a temporary relief hearing, depending on the timing of everything. At temporary relief, you have usually a 30-minute to an hour hearing in front of a judge where you say to the judge, since the beginning of this case and until the end of the case, we need to resolve these issues with you. Usually they're visitation and time-sharing issues, they're short-term support issues, child support issues, things like that. But you only have an hour to ask the judge to basically help you hold the gap between the beginning of your case and the end. After temporary relief, everybody starts gearing up for trial. Depositions take place, and a lawyer's going to want to take depositions so that they know what the witnesses are going to say. Discovery continues to be exchanged. If forensic accountants are involved, the forensic accountants get together and figure out what the numbers are that are going to be presented to the judge. They may be different numbers, but at least everybody will know what page each other is on. And at that point, you end up in trial. And trial doesn't have to be every single issue. Sometimes it is. Sometimes it's a parenting issue, an alimony issue, an equitable distribution issue. Maybe we're enforcing a prenup that somebody doesn't want enforced that may even be unenforceable. At trial, you get to finalize everything, and that's it. At trial, it's where the judge says, your marriage is irretrievably broken, you've met the residency requirement for the state of Florida, and I am divorcing you. And at that point, a trial judge is making a decision about two people and their family in a courtroom where they've only received the evidence that they could receive in a box within the rules of evidence. And that's the end of the case at that point.